What's up? Are we going? I think we're starting here. All right. Full disclosure, as we start our discussion, if anything happens, like if they gave a verdict that I didn't see, let me know. We will react together. I have been wall-to-wall working since watching the closing arguments this morning. And so I haven't seen any updates, right? The last thing I saw was the prosecutor's rebuttal. If they have a verdict, tell me. And we'll talk through it. If I can look it up while we're talking, then we'll talk about the verdict. But before we get to the verdict, I want to say a couple things, and then we're going to get to the closing arguments to start, okay? First, thank you so much, everybody that's here. It's already crazy just compared to how many people we started the last one with. Okay, so I said they did give a verdict, okay? So they did give a verdict. I don't know what it is yet, so we'll react together when we find out what the verdict is. Before we get to the verdict, I think I know what it is. I was going to save my projection until the end just in case the verdict hadn't come, but we'll see what happens. So we're going to talk a little bit about the closing arguments. Okay, guilty on all counts. All right, no surprises there. No surprises, especially after the closing arguments. So let's get to those. But thanks, everybody, for subscribing. Like the video. Make sure you subscribe. We're going to do more of these. There's somebody sent me a crazy trial today about a 16-year-old girl and her 18-year-old boyfriend posting a video 3 days after murdering her father. So I think that's going to be the next one we're going to jump into. We're also going to follow the Fucci case. So there's a couple cases coming up that we are going to follow. So make sure everybody stays tuned. Make sure you subscribe and make sure you come on and join us on all the lives because they're really fun. And I love interacting. I love getting the questions. Before we get to the questions, though, let's just break down the closing arguments pretty quickly since now that we know what happened. And I wanted to start with the states. Okay, so we didn't talk much about the prosecutor's opening statements. I don't know how to share this stream. It's my second live ever, so I don't know how to share it. If you were talking to me. So closing arguments, okay? So I want to talk about the states a little bit first. I know everybody wants to talk about Ronnie's, and we'll get to Ronnie's closing argument. I actually think he did a good job. I realize he's guilty on all counts, and that's not surprising at all to me. But when we talk about the closing argument that the state gave, okay, I thought it was a really good job by them pointing out the facts and pointing out the evidence, okay? They pointed out the fact that there was only evidence proving guilt. There was no evidence that the defense brought to the table that could actually be argued and used as evidence because what Ronnie said as a lawyer representing himself was not evidence from the stand. Just so you know, I'm also got some ADD. I'm not going to read the comments as I go through the closing arguments. Then we'll jump into all the questions from the comments. So one of the things throughout the state's closing argument is they kept saying little Ronnie and then his last name, which people got mad about me saying it last time. It's on all the news reports, but I'll try to refrain from saying little Ronnie's last name and just call him little Ronnie, which is what the state did throughout their closing. Okay. That's something I absolutely object to in the beginning as a criminal defense lawyer. You don't want the state making it even worse by calling him little Ronnie. Okay. But Big Ronnie did not object. So the state just called him that throughout. Okay, that's usually problematic and usually prejudicial. So you usually don't want that as a lawyer. Just there's some nitpicking I'm going to do just to show the differences between a pro se lawyer and an actual criminal defense lawyer. So the reason I'm not going to show you any clips from the closing argument that I watched live and we shared live on our page, so hopefully a lot of you guys already watched it. The reason we're not going to show it is it's been taken down most places. I couldn't find all the clips that I wanted from watching it live, because they actually showed the pictures of the minors, of his daughter, of his son, actually on some of the live streams. They also said their names on the live streams. There was also a ton of cursing throughout the closing arguments on the live stream. So that was problematic as far as pulling clips, and YouTube took down a ton of their clips. So that's tough, and I'm not going to have any clips to react to. Hopefully in the future I'll be able to give some and we can talk through them a little bit more, but hopefully you guys have had a chance to actually watch the closing arguments at this point. The prosecutor focused a lot on the 911 call, okay? They said Ronnie Sr., and I'm calling him Senior and Junior. I don't know why I respond to the haters, but you know, they hit me in the comments, and I do read the comments. And they said they're not Junior and Senior, they're the third and the fourth. That's fine. They were called Junior and Senior throughout the trial. Everybody referenced them as Junior and Senior. So I'm just going to reference them as Junior and Senior. So forgive me. So they played the tape that they said Ronnie Sr. had no idea that Ms. Barron was on the phone with 911, and it was actually true, and you could hear him say a ton in the background, and they focused on that because that is our other witness in the case. We have young Ronnie who testified, but you know, Big Ronnie poked holes in his argument or in his testimony. And he did a good job in closing, and we'll get to that. But this 911 tape was also there the night this incident happened, and it was ears on the ground for us to actually hear what Ronnie Sr. was saying. I'm going to kill that B. Come help me kill that B. Allahu Akbar over and over again. Ronnie, go get me the knife. They really focused on what you could hear from the 911 tapes. Okay, that was a lot of the prosecutor's argument, and I think it was good. Some of the worst parts of the closing argument that I think was the most damning for Ronnie Sr. was when the neighbors saw him bludgeon his wife and drag her dead body by the arm towards the house. The neighbor comes out, and then Ronnie's like, oh, she tried to kill me. He runs inside, then he calls 911. So that timeline is important, I think, to show his guilt and his consciousness of guilt. Okay, that was some testimony that I think was really damning for him, along with the 911 tape. They say they made some arguments about, again, just this is the worst factual scenario I could think of, but they talked a lot about how his autistic, special needs 9-year-old daughter couldn't even stand up for herself, couldn't beg, Daddy, please don't do this to me. She couldn't defend herself. She couldn't argue. She couldn't beg. She couldn't do anything. And that was soul crushing if you're on the jury and you've got to make this decision as to who murdered this poor little girl. And I think the prosecution did a great job at pulling at the heartstrings throughout the testimony to realize how bad this is. Okay, we have all these theatrics. We've got Ronnie doing a pretty good job defending himself. We've got the stuff we may never see again, where he's cross-examining his son, who's also the victim. He's cross-examining his son's new adopted father, who's also a detective investigating the case. So there are some legal nuances we may never see again. But putting all the circus aside, this is still a case about a double murder and an attempted murder, 2 of whom are minor victims. So, I mean, it's basically just an impossible situation to get through without, it tugging at your heart. And I think the prosecutors did a good job of doing that. They did mention Ronnie Jr.'s inconsistencies, which I think was good. That's something the jurors are going to think about. That's something that Ronnie Sr. talked about so much, and he just hammered it home in his closing that there were so many inconsistencies. Which one can you believe? The interviews that happened 7 days after the murder, or the trial years later? Which one is more accurate? The one that happened right after, or the one that happened way later? The one that happened in this special expert, Miss Miller, who's an expert at getting the correct and truthful information out of minors that have gone through trauma, or today at trial after his new dad, who shouldn't have been allowed to coach him, has coached him, right? So the prosecutors mentioned, they say, we agree there's some inconsistencies, okay? We agree that Ronnie said some things different right after the incident happened and different from what he said today. He was suffering from PTSD. That's to be expected. But where there's not inconsistencies is what you can hear Ronnie Sr. saying in those 911 tapes. And I think they did a great job of, we like to dispel our warts as lawyers. We want to not be afraid of the bad parts of a case. We want to explain them. We want to say, yes, there were some inconsistencies, but that doesn't mean everything he said is a lie, because even Ronnie Sr. is going to rely on certain things that Ronnie Jr. said. So either, you can't have it both ways. You can't say just the bad stuff is a lie, but all the good stuff is the truth, right? So that's something that the prosecutors argued, and I think they did a good job with that. Let's talk real quick about the counts, and I've noticed kind of out of the corner of my eye, some people talking about premeditation, first-degree murder versus second-degree murder. So the prosecutor did a good job of explaining premeditation in a way that made it more viable for the jurors, obviously, to convict Ronnie Sr. He said that premeditation, which a lot of people don't know, doesn't mean you had to plan out for weeks and months and buy all the tools and make this big plan, and right when she comes home, aha, this is when I'm going to do it. That's not what premeditation means. Premeditation, as he explained it, just means you have to have time to reflect, you have to have time to make the decision, and you have to have time to, what does he say here? He said it has to be present in your mind at the time. The law does not fix that time, and there must be enough time to allow reflection. Okay, that was his way of explaining premeditation. I don't know if I would agree with that as a criminal defense lawyer. I think it needs to be more than that personally. I think you do need to have time to actually make a conscious decision that I am going to try to kill this person and not just in the heat of passion kill them, okay? I would have pointed that out more if I was Ronnie's lawyer. Obviously, I wasn't. He defended himself. But the prosecutor did a good job of kind of lowering that burden of premeditation. Premeditated first-degree murder, but also first-degree murder for his daughter. And so that it was kind of harder if there was more or less premeditation. What the prosecutor said is after he killed his girlfriend, he had plenty of time for reflection as he walked back inside the house and dragged his daughter across the house to hatchet her to death. Okay, so I'm not sure if that shows premeditation, but what he did do, which was even better, is he said there's also felony murder because there was aggravated child abuse that resulted in a death. We learned a lot about felony murder when we talked about it in the Derek Chauvin trial, because that was one of the counts against him, that even if he didn't plan to kill George Floyd, he was committing a felony and a death occurred. Therefore, there's first-degree felony murder. So kind of a similar argument. In this case, we have the aggravated child abuse, which is a felony, and a death occurred, therefore felony murder. That's how the prosecutor explained it. Then you have attempted murder on Ronnie. We know there were stab wounds on Ronnie. We knew he bled throughout the house. They talked about all the blood spats that came back with DNA matches for Ronnie Jr. and no one else. So we knew that he had these injuries, even though he said in his testimony right after the incident occurred to the officers that his dad didn't hurt him. And on the stand at trial, he said his dad did hurt him. And Ronnie Sr. kept trying to argue that it was actually the mom that did all this to them. We know that he was injured. The attempted murder, I think personally, was the hardest charge to prove because of those inconsistencies, because those inconsistencies were difficult to kind of get around to prove beyond a reasonable doubt. And then the last one I want to talk about is arson. So setting fire to the house. This one was also, I don't really know what Ronnie was saying, if anybody else set fire to the house. I didn't understand his argument against arson or why he would light the house on fire. I thought that was a great point by the prosecutor, who said, why would an innocent person light the house on fire? If it really was self-defense, why would you go back and light the house on fire and burn all the evidence if you were trying to prove that you didn't do this, right? So I thought that was a good argument, and the arson is pretty damning. Let's see here. Okay, so some points about it being a pro se defendant representing himself, right? And here is why I was going to give my prediction for guilty on all counts, okay? The only one I would have ever had any wavering on if I was a juror would be the attempted murder on his son, is stuff like when the prosecutor said all of the evidence points to this man, that this man committed the murder on his own children, and Ronnie says something and the prosecutor doesn't hear him, and the prosecutor said, was that a legal objection? And Ronnie said, I said you better watch your hands, okay? Listen, in normal life, that may be okay to say, and maybe okay to kind of puff out your chest or say those things. But when you're in the middle of a trial for a murder, a violent crime, and you're threatening the guy doing his job as a lawyer, and the judge has to admonish you to keep it to legal objections, that doesn't look good. And I think those are the things that really hurt Ronnie throughout this process, is them watching him, how he acted at certain points, how he seemed at certain points, the comments he would make at certain points, I think just did not serve him well as he was trying to represent himself in a murder trial, a trial of a violent, heinous crime. A ton of comments, maybe not here yet, but a ton of comments throughout some of the other videos that I've seen have said, just think about how angry he could be if someone really pissed him off. Think about how angry he could get in a situation where he felt like he was wrong. If he can get that angry at a prosecutor just doing his job, if he can get that angry to scream in court like that, if he can get that angry to act like this, imagine how bad it could be when things actually went bad for him. So that did not help him, I don't think, in the mind of lay people who are jurors. Okay, so that's something that I think we should keep in mind. Let's see here. All right, let's jump into Ronnie's closing now, okay? So fireworks were had, okay? I mean, we got fireworks from Ronnie's trial. We got cursing. We got saying all sorts of things that you shouldn't say in open court. Yes, the prosecutor did curse him. If you're repeating something that was specifically said in evidence or repeating something on the 911 tapes, yes, it's okay. It's fair game to curse in court, but you don't want to do it unnecessarily. And Ronnie continued to do it, continued to just say those phrases over and over and over again, and even add his own, saying that's BS. That's all BS. I turned to my counsel and I said, that's BS, which leads me to my main point. This morning, I did a video prior to the closings to see, I'm so interested to see how he is going to act and how the prosecutors are going to act in the closing arguments since he didn't testify. Is he just going to try to use this closing argument to testify? And the answer was yes. He tried to say, I know for a fact this happened. I saw this happen. I said to my attorneys, this didn't happen like that. I'm sure of it because I was there. And the prosecutors did object over and over again to facts, not in evidence, which was a perfect, proper legal objection. They didn't make any intimation that this was, he should be penalized for not testifying, which is so important because you don't want to penalize anybody for invoking their Fifth Amendment right. because that is a constitutional right. It's there for a reason, and it must be protected above all else. And the prosecutors did a really good job of objecting, just saying facts, not evidence. And it was really interesting, if you were able to watch and listen to my videos before, the judge said, Mr. O'Neal, we've been over this. You've been instructed that you can only talk about things that were said from the stand that came in as evidence. And she was intimating, you didn't take the stand, so you can't say those things because that's not an evidence. Really, really important. Okay. Okay. Where his argument falls so flat. Okay. And then in the rebuttal, the prosecutor said, this is the problem with conspiracy theories. They fall apart when they're not true. Okay. Because in order to believe Ronnie's story, you have to believe that the prosecutors and the government got these tapes, did voiceovers, changed the words, changed the recordings, deleted 911 calls, superimposed other people's voices, then convinced a random neighbor to come testify against Ronnie, saying he said something in a doctored 911 tape. It just doesn't happen like that. I think Ronnie did a great job in his closing talking about how the different time zones that they post them in. Where is this 911 call? Why is it gone? Why do the T-Mobile records not match the 911 records? I'm going to prove it to you right here that this is where I made that call. I thought he did a great job with that. The problem is the fact that the call is not on the call log doesn't change the fact that we all and the jury heard the words from that 911 call. They heard Ronnie say those things. They heard Ms. Barron say those things. They heard the chaos in the background. So whether or not it's on a call log, I don't understand how far that goes. You tell me. Does that mean more to you than it does to me that maybe they were at different times or shifted up or down because the time change or whatever? Does that mean more to you than it does to me with the fact that we did get to hear those calls? It's not like Ronnie said, this call exists. Why don't we hear this 911 call? Right? That would have been more damning. He's like, this call exists and we don't hear it. He says they doctored it. The times are gone. It's not on the call log, even though we heard it. Just kind of less powerful to me, even though I think he did a skilled job explaining it in his closing argument as his own lawyer. Okay, Khalil Brown. We talked a lot about why in the world did he call Khalil Brown, right? We were all thinking Khalil Brown came and testified that he bludgeoned Ms. Barron to death. So why would he call him? It was actually a good argument, I thought. He said, Khalil Brown, he said he was sure, and I brought him up there. He said, I only hit her 3 times. If you listen to this doctored 911 tape, there's 10, 11, 12, boom, boom, boom. And that was, first off, that was miserable to listen to actually on a recording. But he's showing a major inconsistency, okay? And he also said, I told you I hit her 3 times. Not in evidence, but he did say it in his opening and in his closing. He said, I hit her 3 times. And he confirmed what I said was the truth. Not what the prosecutor said. The prosecutors want you to believe I hit her so many more times. Khalil Brown showed an inconsistency. So as bad as that seemed for him at the time that Khalil Brown was on the stand, it actually made a major inconsistency in the prosecutor's case. And I thought Ronnie did a great job calmly going through and explaining that. You guys may not know, it is very difficult sometimes to keep all these different arguments in your head, make sure you have a clear outline, and be able to explain it to lay people and to jurors in a way that makes sense. Sometimes you can start rambling and going here and going there and taking U-turns and forks in the road. He did a really good job, I thought, of methodically going through a lot of these inconsistencies and explaining what he knew what we were thinking. He knew sitting at counsel table that we were all listening and thinking, why would you call Khalil Brown? That makes no sense. He was bad for you. I even said it in one of the videos. Why would you call him? And he had a reason. He had a method to his madness that he called him to show this inconsistency. And it's much more likely if you kill someone in self-defense to only hit him 3 times than to hit him 12 times. I think that argument jives. I think that argument makes sense personally. All right, so let's see here. And he said, I know I hit her 3 times. I told you in the opening, literally I was there. And again, more objections and things like that. All right. And then on the call log, there were a couple calls between him and the victim where he said, and this call happened earlier that day. And what would happen in this phone call, and the prosecutor stood up and objected because that's not an evidence. And he can't testify to those phone calls because he didn't take the stand. And he's not going to get cross-examined on what happened in those phone calls. So I think that's important as well. Kept on cursing throughout. There were tons of fireworks. Let's see here. Yeah, again, he argues with the judge a couple times on objections. He tried, and this is where you can just tell he misses the boat as a pro se defendant when he says stuff like, well, they argued that it wasn't self-defense and those facts aren't in evidence. And the judge is like, they can make those arguments, Mr. O'Neal. And he tried to make it the same as when they argued that he's saying things that aren't in evidence, like what happened in a phone conversation between him and the victim that nobody has testified to. And those are, in fact, facts not in evidence. He talks about justifiable homicide. I had a ton of comments from people watching the prior video saying, he admitted he killed her. It's over. It's a wrap. But that's not what he was doing. In order to have a self-defense claim, you have to admit that you did do the killing, but that it was justifiable. It was justifiable that he killed his wife because she was trying to kill him and it was self-defense. So he was not admitting the crime that they charged him with. He was just saying, this is what happened, this is why I killed her, and this is what happened, okay? And then a lot of other comments about, well, who killed the daughter? He never said who killed the daughter, and he didn't, and it was not in evidence, and nobody else ever said that Ms. Barron killed the daughter as opposed to Ronnie. But in his closing, he said, that's why he showed the picture of his daughter. That's why he showed the picture or explained the picture of his son. He said, you want to know why I killed Keke? This is why. And he showed the pictures, which without testifying was very smart and skilled. He showed the pictures saying, this is what happened to my kids. I love my kids. I thought he showed good emotion in his closing. I thought he seemed sad that this happened to his kids. I think he showed a lot of emotion, and I think it was good, and I think it was well taken, okay? And he explained point blank, even though he didn't say Keke killed my daughter, he said, this is why I killed her. This is why I killed her. So he explained it without actually having to testify and without having the prosecutor stand up and object to facts not in evidence, which I thought was skillful. Okay, then I thought his argument, again, this is something that criminal defense lawyers do all the time. It's me versus the machine. It's all of them against me. This happens to people like us, okay? He made those arguments, and I think there are a lot of jurors that those arguments stick with, okay? It's, you versus the world, the little guy versus the big bad government. Those are arguments that happen in lots of trials, but sometimes pro se defendants don't pick up on them and don't make those arguments properly, and I think he did. He did a great job of going through, this is what I told you was going to happen in opening, and this is what happened in the trial, connecting that. He told the truth. He said the evidence is going to show this, which is everybody's favorite slogan now. And then he said, this is exactly what the evidence showed. The evidence showed that they doctored the 911 tapes. And look, here are the 911 logs that are wrong. The evidence showed that Ronnie Jr. said this, but this is the truth because he said this closer to the incident. And he said, that's what the evidence showed. So he went through and said, you can trust me. You know what I'm saying is the truth because what I told you you'd see in the trial is exactly what you saw. I thought he did an awesome job going through all that. Okay. Now, another big miss from him, probably not a big deal. The jury came back quick now. We already know that. The suspense is kind of gone, but he said multiple times that they did not prove by clear and convincing evidence. That is not the standard in a criminal case. It is beyond a reasonable doubt. Clear and convincing evidence is a lower burden than beyond a reasonable doubt. That's something a criminal defense lawyer would never, I hope, do. That he did as a pro se defendant. Again, I don't think it really matters because the jury was explained what the law was by the judge. And then in rebuttal, like I said, the biggest thing he did was conspiracy theories fail. They don't make sense. He gave a Benjamin Franklin quote about something like a secret between three people is only safe when two of them are dead. And that's what Ronnie did here to keep his secret safe. And then here was the most damning point in the entire rebuttal when the prosecutor said, until this trial, Ronnie's been interviewed by law enforcement. He had a call to his stepdad after it happened. We have statements from Ronnie, and never did he show remorse for what happened to his children, except for right now in his closing argument. Never did he ask about how they were. Never did he mention what happened to them to anybody. Even when he talked to his stepdad and he said, I had to kill her because she was trying to kill me. Never did he show concern for his children. Never did he say, she killed our daughter, that's why I had to kill her, right? And I thought that was damning because somebody can come up with a defense on the fly, but you can't go back and fix everything always to make it fit your story, especially if it's a conspiracy theory. Okay, yes, so people are still commenting that guilty on all verdicts. Guilty on all counts. The verdict is in. We'll talk more about that. We'll get more reaction. Tell me if you guys agree with that in the comments. I'm going to start scrolling through all these comments. I'll get to as many. I'm going to try to click them, put them up on the screen. I'll get to as many of them as I possibly can. All right. Let's see here. The 911 call was gnarly. I agree. People said it was horrible to watch him in his closing argument. Let me know your questions. Now is the time for the questions for closing, for the verdict, whatever it may be. 3 times, 12 times, she's dead. I agree. And that's something I thought as well. So Brianna said, like, does it really matter that it was only 3 times? I assume is what she means by this. Like, you don't bludgeon someone in the head with the butt of a shotgun 3 times because you don't want to kill him. But I agree. I didn't think that was, if I was on the jury, I would say 3 times you bludgeon her in the head after shooting a shotgun at her arm. Like, he couldn't get through some of that stuff. And her blood inside the closet while she's on 911, screaming, crying, asking for him to stop, saying, I'm so sorry. I love you, Ronnie. That was damning. Yeah, I agree. I didn't think 3 times seemed light. So there can be enhanced penalties for killing the elderly or somebody with special needs. There can be enhanced penalties for that, but he is getting the worst. We're in the penalty phase now. I assume if what everybody's saying about the verdict being in that he is guilty of first-degree murder, we're going to start the penalty phase for the death penalty. So there's no enhanced penalty to the death penalty. So he's kind of got the worst of the worst. So this is a quote. Did I hurt you that night, son? You stabbed me, but the son said he did not hurt him and he did not stab him when interviewed by law enforcement just a week after the incident. So I think that is kind of an inconsistency. I mean, horrible. And obviously the jury didn't buy it. The jury bought that the son was stabbed by the dad if he was guilty on that count. So I did watch some of it. I didn't watch the whole thing. Now, something you need to know, okay, in case you guys can't see it. Did anyone watch the Casey Anthony trial? Jose Baez accused George Anthony of crimes in his opening, never brought him up again, never proved them. Okay, so we've talked a lot. The defense doesn't have to prove anything. And as the prosecutor chooses what to charge the defendant with, the prosecutor has law enforcement. They have all the resources. They have all the burden. They have to prove everything, okay? So if a prosecutor says something in opening and never brings it up again, that is a much bigger deal than if the defendant does it, okay? As unfair as that may seem, the defendant is not always held to the same standard, and the prosecutor can't appeal and then try the person again because of double jeopardy. So if it was an appealable issue and it was just something like that, it's not going to be enough to try him again. Unless it was something, horrible, or there's new evidence or some real remote reasons. But the burdens are not always the same with the prosecutor and the defense. The defense attorney has a lot more leeway, especially if it's a pro se defendant like this case, a huge amount of leeway when compared to the prosecutors. Okay, so here we go. See, this is representative of a lot of the comments I saw. Just because he said he killed her does not mean he's admitting to the crimes. Okay, the verdict is guilty. I understand that, but that's not what he was doing. He was setting up his legal argument for self-defense, which you have to admit in this case, if he stipulated, which the prosecutor said he stipulated that she died, he has to admit that he killed her, but it was justifiable. A justifiable homicide is what he continued to say. Did he get the death penalty? We don't know yet. So, Joanne, I mean, I think he can be crazy and smart at the same time. I mean, there's no doubt in my mind he's smart. Okay, I don't know because I'm not a psychiatrist. I didn't evaluate him to see if he's crazy, but he's smart. He puts together things that a lot of people can't. And the way he explained them, it's really sad that this happened to him, because just watching him throughout this, I'm not being facetious or just trying to, make something out of nothing. I'm being serious. He was better than some lawyers that I see. No, there's lots of, you can give me reasons for that, but I was impressed with how he argued. Now, they found him guilty on all counts. So as far as I'm concerned, he's guilty of it and he deserves what's coming. And whatever happens, he deserves it if he did it. And the fact that they convicted him legally means he did it at this point. So, whatever happens to him is fine by me, but I still think he did a good job. And I'm sad that this is kind of how it ended up for him. Yeah, another same about the rage is an intelligent man. I agree. Okay, some people commenting to each other here. Let's see if we have any more. Some people saying I have no sympathy for his girlfriend. So, I mean, that's Ronnie's, that's what he was trying to do throughout the trial. Yes, Florida does carry the death penalty. They don't always ask for it, even in first-degree murder cases. They kind of save it for the worst of the worst. They did ask for it in this case. but it's two separate phases. So they have to convict him first, which they've done now. So everyone's telling me. And the next phase now is whether or not they're going to give him the death penalty. And the jury recommends the death penalty. If they do, they recommend the death penalty, but the judge is the one that then can make the decision after that. Jurors found him guilty on all 7 counts. Thank you, Flippo. Sounds like he pulled this right from a news article. Yeah, and like I said, First Lady Genevieve, they pulled down a lot of the closing videos because of the gruesome nature of the pictures that they didn't edit out, and they just kind of played them through, and they said the minors' names, and there was a ton of cursing. So usually they would edit that stuff out for the public to view, but because it was live, a lot of that didn't get it out, which is a big oops on some of these news channels. The state did not prove murder one, according to Yarok Entertainment. Well, according to the jury, they did. And that's the other thing is, just as a lawyer, I'm not saying I know everything, but once a jury reaches its verdict, until it's overturned on appeal, that is the answer. That's the answer we have right now. We don't have to agree with it, but that is the answer. And to this jury, the prosecution did prove murder one. Usually the sentencing phase is later. I haven't, like I said, I haven't seen any of the articles even on the verdict yet, but usually the sentencing happens later. No appeals from Fine China. No appeal. He doesn't have a leg to stand on. I disagree. I think there will definitely be an appeal. What will be interesting now is, does he do it himself, or does he get a lawyer to appeal the case? There's going to be all sorts of fascinating issues because he represented himself. Okay, it's not going to be ineffective assistance of counsel. It's not going to be because the defendant didn't testify or anything like that. But there is going to be an appeal. There almost always is, especially in these kinds of cases. Actually, death penalty cases, they have to do certain appeals. They have to if they end up enforcing the death penalty. So we're going to see appeals. It's supposed to be the prosecution's job to prove their case. So check the out. Not to prove innocence, I agree, and I think that was done in this case. I mean, I think the prosecution did put on a lot of evidence, and I think for the most part, Ronnie poked holes. Besides trying to prove his self-defense, I guess, which you do have to prove if you're going to claim self-defense. But you're exactly right, and that's what happened in this case. A little late to show he cared. So Asante, you're right. That's exactly what I said while he didn't testify to it because he didn't take the stand, there was no evidence of it. He showed those pictures and said, this is why I killed her. You wondered why I killed her. Now I'm telling everybody, this is why I killed her. Look at this picture. So he said it without saying it, that his wife killed his daughter. Okay, so Chuck Robinson, I used to have a very good friend named Charlie Robinson. He showed no evidence of government fraud though. Okay, I agree with you. Now, I think he tried to blow up the whole doctoring the 911 tapes and superimposing other people's voices on it and changing his voice and speeding it up or slowing it down or chopping it up. I just don't think that proved government fraud. That's the issue. Is I don't think that proves government fraud either. Now, the detective adopting his son and coaching him as a witness or coercing him, I mean, I guess that's more government involvement. I just don't think, I agree with you. I don't think that he proved government fraud at all, which is why it's so hard and why 99.9% of lawyers will not argue government fraud, conspiracy theory, doctored 911 tapes. We don't argue that. Clients want us to argue it all the time. We've had cases where there's thousands of hours of recordings of clients saying things, and they're saying all of it's fake. They made it all up. We need to get an expert to look at this and break down the tapes and show where there's cuts and where it's been doctored. And most of the time, it's just not worth the money because it's so clear that it's not doctored. Sentencing phase, according to Flippo, begins on Wednesday, so we'll keep an eye on that. All right, let's see. From Checky again. Did the evidence show beyond a reasonable doubt that he killed everyone in the house? The discrepancies allow for reasonable doubt, don't they? I agree with you as far as the attempted murder of his son, that there were potentially reasonable doubts to that. But if you're going to convict him on all the other murders and all the other charges, then how does it make sense that that Miss Barron stabbed the son but didn't do any of the other stuff, right? So it kind of falls in line, I think, with logical thinking, common sense, with jurors are always trying to use their common sense. I think there was no doubt that he murdered Miss Barron. I mean, there were witnesses seeing him bludgeon her in the head with a shotgun. The 911 tape, you could hear it. And he did not take the stand to say she did anything that caused him to fight her back in self-defense. That's a huge key. There was no evidence that he needed to act in self-defense. That's the problem. So there was no reasonable doubt, and there was no proof of self-defense, especially to Miss Barron. And then to the daughter, there really was nothing about what happened to the daughter except for Ronnie Jr.'s testimony. So again, that's the only evidence in the case. So there was no real doubt to that evidence, unless you just flat out want to throw out everything Ronnie Jr. said. Then I guess you could have found reasonable doubt on the murder of the daughter and the attempted battery on the son. But then the arson, was there evidence that anybody else lit the house on fire? Ronnie had the wounds that you would have if you lit the house on fire, burning just your arms, and he smelled and reeked of gasoline, and there were empty gas cans around. I didn't see a lot of reasonable doubt in those charges. So the judge actually said he would have made a good lawyer in another life. 250 Gaming, thanks for posting that. I agree. It's really sad. I think something similar was said to Ted Bundy. I can't remember exactly. We did a whole podcast series on Ted Bundy way back in the day if you want to check our archives. But I think the judge said something like that. Like, it's too bad because in another life, I think you really could have been either a good lawyer, really smart, successful guy, something like that. Did he prove the calls were missing? IB Elf. I don't know if he proved they were missing, right? He proved that the times were different on the call logs. He proved that they had a call from 911 that wasn't on his log, but we heard the call that he said he made. So it's not as if a call disappeared. It was, I made this call at 11:42 or whatever it was. You heard that call at 11:42, so we know it exists and you heard it, but it's just not showing up on this call log. So does that prove it doesn't exist? Is that enough to prove they doctored the evidence? You tell me. So here we go. I wonder if the jury thinks he's too crazy to give him the death penalty. So in an insanity defense, I think this would be a much better argument, but because he's saying he's fully competent and because doctors have said he's competent to represent himself, I don't think this is going to be an avenue they can take to go away from the death penalty. And also something that was very interesting to me is during jury selection, Ronnie actually said he was a proponent of the death penalty. And if somebody committed these types of crimes, they deserve the death penalty. If you convict me, I deserve the death penalty, things like that. He also wanted to strike a juror that he thought said, and he was actually incorrect, he thought the juror said they don't believe in the death penalty, and he said, I want to strike that juror. So I don't know. I think it's going to be, the death penalty phase could be interesting as well. All right. Very sad situation. I agree with that. He doesn't go straight to death row, not until the sentencing, if they do give him the death penalty. I agree, and I think the prosecutors answered that with a lot of the witness testimony, especially Ronnie Jr. And he had another thing, Ronnie Sr. had no defensive wounds, and everybody else was just gashed up. So that usually is not an indication of self-defense. I don't know. I don't know if they're going to record it. I think we all might be surprised at his stoic reaction. I don't think he's going to have a huge reaction. I think at this point, he's got to know the death penalty's coming. Okay, let's see. Yeah. So I'll hail King Rose. Years ago, when this was first reported, it was said he was trying to convert them to Islam and he was doing a lot of chanting. The prosecutors did say things like that throughout as well. And that was one of the reasons he was getting frustrated, because they wouldn't, and the mom was fighting against it. So that was kind of just like an ancillary issue that they did bring up. But we definitely heard a lot about his chanting. See, Drizzy Drake, I assume it's not actually Drizzy Drake. Did the yelling and opening help or hurt since he didn't do it now? He did yell a little bit, but I thought he was much better about going louder and softer and louder and softer and having a better cadence to his voice in closing. I agree. Maybe he learned something. Who knows? That was his first ever opening statement, his first ever argument in front of a jury. Little Miss Beauty 01, what's the reason he decided to represent himself? Well, what the reports were is that his lawyers were not agreeing with the self-defense angle or the self-defense defense. He wanted to do it. He got rid of them and did it himself. Usually it's just a disagreement between the defendant and his lawyers, so he could say they're not representing him. I showed the letter last time that he wrote to the judge saying, they're not representing me properly. It's ineffective assistance of counsel. I need to do this myself, and he was obviously allowed to. So Vincent Douglas, when you represent yourself, can you get legal assistance? And the answer is yes. You can still get legal assistance. You can have standby counsel. His public defender, I believe, was sitting at the table. We saw her a couple times. He pointed to them a couple times and referenced depositions that they took. So he can still get assistance. He can still ask them questions. They can still help him if he wants to. But I was watching certain parts of the prosecutor's closing, and the public defender sitting next to him had a cat on the background of her computer and no documents open. Her computer was just open and on. There was nothing on there that she was really assisting him with that I saw. I don't necessarily know if this is true, Patrick Neal, that he killed the whole family because they wouldn't convert to Islam. I think that was just, they were trying to find motives, things like that. Because at this point, we're actually, this is 250 gaming again. Why did the judge say this part of the trial, which is the penalty phase, is more serious than the actual trial? Because now we're talking about a person's life. We're talking about the automatic appeals that are going to happen if it's a death penalty. Death penalty is not very common. So this is a very serious part of the trial. I don't know if I would say it's more serious, but it is very serious. Charity Dunning, could he have hired / called an expert witness to prove fraud or false audio or whatever? Seems like this trial could have gone on much longer for a capital case. A money issue. I agree with you. I think if he really had evidence that these were doctored, he should have gotten an expert to look through them. Now, when you have the public defender, you have to get stuff like that approved, and it has to be necessary because it's taxpayer dollars, not your own money. If you hire a private defense lawyer and you have the money to hire these experts, you can put that defense on. So I don't know if there was a money issue or if there was just a necessity issue that he couldn't hire these expert witnesses, and that could be something that comes up on appeal. He didn't have the opportunity to get the expert witnesses that he needed. We'll see. So Tony Hobley said, in an appeal trial, will it be the same prosecutor? So it's not an appeal trial. What an appeal is, they look through the trial testimony, they do a bunch of research and put together what we call a brief, which is funny because it's not brief, it's very long. So they put together a brief and there are rules. It can only be 25 pages with this 12-point font, whatever it may be, depending on what jurisdiction you're in. You put together that and you send it up to judges who just read the briefs. Then you could be allowed oral argument, which you go in front of the judges, you answer their questions, you give an argument as to why this appeal should take place, why your side should win. You're either the appellant or the respondent. And you make that appeal. Sometimes it is the same attorney, especially in a prosecutor's office. Sometimes they have an appellate division. So if they have an appellate division, those are people that specialize on appeals, and they'll usually be the ones to go and do the appeal, not the actual prosecuting attorney. But the prosecuting attorney at the trial will be heavily involved because they already know all the facts, they know all the evidence, and they know exactly what happened in trial. I agree with you. So all hail King Rose. Another point that goes against self-defense is that he chased her down outside. That was the evidence. He chased her down and beat her to a bloody pulp with the butt end of his shotgun. That's not really what self-defense looks like in most cases. Most stand your ground defenses or self-defense cases, you fear for your life immediately at the time that you kill the other person. That doesn't seem to be the case here. Susan Lloyd confirms that the judge basically said the same thing to Ted Bundy. I'd be willing to bet that this judge actually looked into that case because, like I said, there's not a lot of cases like this that are high-profile murder cases dealing with pro se defendants. I would be willing to bet that that judge either, tried to do as much research as she could on that kind of case to see how it was handled, what was handled positively and negatively, especially in the media. Yeah, Candy A, before the trial began, he told prospective jurors he believes in it. Yep. That's going to make this even more interesting. Okay, here we go. We've got the quote. When it comes to the death penalty, I just want to let you all know that me personally, I am for it. If somebody has committed these crimes, they are worthy of death. That's what O'Neal said. Thank you, Candy. Yeah, so I mean, that ain't good. Yep, King T'Challa's back for more. Means you can die. So that's in fact what the death penalty is. Vicky, I didn't see it. I was going from one work event to another until I just showed up here, and you can probably see over this shoulder, my dinner that I just ate before we started. I didn't see his reaction, so if anybody wants to fill me in on his reaction, I'll watch it later and we'll talk more about the verdict. Let's see. Yeah, okay, so this was good. So Latoya Esquire up next. There was like a couple mentions of the fact that Ronnie Sr. made Ronnie Jr. hold the shotgun and point. And when Ronnie Sr. asked Ronnie, was it Ronnie Sr. asked him or the prosecutor asked him? I can't remember. If he fired a shot with that shotgun, Ronnie Jr. paused for a long time. Like for a long time, so long that I'm not even sure he answered that question before they moved on, which I think was the prosecutor. I think the prosecutor asked him, when he made you hold that gun, did you fire a shot? And he really didn't answer that question. That was a very weird set of circumstances, which I think personally, if I was a juror, that would just make me think, this is even worse than we can imagine. I mean, he's trying, and again, they hit on it a ton during the closing. He was trying to get his son to do this murder with him. I mean, that's not aggravated child abuse. I don't know what is. So Yaya's Playhouse. I think jury duty should be a paid government job that you go to school for and you have to travel to other countries. I don't think it's fair to put our life in the hands of people on the street, okay? I disagree. I think when you send people to school and to other countries and to learn how all this works, they become lawyers and they become judges. And there's a reason that lawyers and judges are not the ones making all these decisions, because you guys, and I don't mean you personally, I don't mean anybody personally, but I mean you guys are the ones going through this. You guys are the ones that potentially could have your life on the line at trial, and you guys are the ones that make decisions for the other people you are living with, and me included. I could be on trial one day for something as well, whether it's, I get hit in a car accident or, I get arrested or wrongfully accused or whatever it may be. Any of us could end up in that chair, and we want people who are just going to look at the evidence and use their common sense and use their experiences, and we want it to be as diverse of experience as possible to make these decisions. That's how the jury system is set up. We don't want professionals, because then professionals can get bought and sold, and professionals could be greedy, professionals could be in on it. It could be part of the machine that Ronnie O'Neal was talking about. It's very hard to get random people off the street to come out of their life, come out of their job, come away from their family for a week, and sit there and have them be part of this scheme and have them be part of this conspiracy. It's much harder to do that and function that way. All right, so Cement Shoe said, I don't see what the difference of time calls made. He still killed a child and her mother and tried to kill his son. I think that's what the jury ended up thinking as well. Yes, I am unique. Yeah, it was. And one of the things was he was saying, we all know it's Eastern Standard Time. This was UTC or whatever he was talking about. He was just trying to show it was doctored, when in reality it was just 4 hours ahead and it was up on the call log. All right, let's see here. What else we have? Donna Gibson. So did the little boy stab himself? I love the law. I know that we must follow the law to the letter. However, I wish we could sentence him tomorrow. I wish we could sentence him tomorrow. So the reason for that is we need some reflection. We need some time. We don't want to rush. We don't want anybody to say the jury wanted to get out of there, so they just said yes, yes to everything, convicted him on everything, yes to the death penalty. There are reasons the rules are in place. We have committees filled with lawyers that argue about what the best process is. So, Donna, I agree with you. We do have to follow the law. So Joey D says he won't get death because he exposed phone log corruption, but we'll get like I mean, I'm hard pressed to call that corruption personally. I don't call that corruption, especially because we got to hear the call he said he made. We heard the substance of it. So Galaxy Galore, a lot of this has to do with, the question is, when inmates get the death penalty, why are they on death row for so long? A lot of it has to do with making sure they are guilty after the fact, going through all of the different appellate channels, going through making sure no evidence comes up to exonerate them. The Innocence Project is a group that goes and looks at certain cases you can apply to have them look at it free of charge and come fight for you to prove your innocence after you've been wrongfully convicted, and they give death row people the highest priority. They're on there for a long time because as a society, we want to do everything we can to make sure they are guilty and deserve the death penalty before we do end their lives. So while it is sad, there's a method to that madness. How much do I think he'll actually serve? I don't know. We'll see. Robert Smith, yes, the state did prove that the murder was premeditated. He was guilty of that first-degree premeditated murder. Yeah, let's keep racist comments out of this chat if we could. O'Neal said he's innocent. Okay, so really, Mariah, thank you for letting us know. He was really calm during the verdict, and that's not surprising to me. It's not surprising. He's been pretty calm throughout. Yeah, a bunch of people posted this for me, so I appreciate that. Okay, so Gabrielle Boudreau, why would they ask the little boy to testify? He's already terrified. I agree he's terrified, but he was the key witness. He was the only one that saw what happened to his sister. He was the only one inside that house that could corroborate what happened and help the state prove their case. He was essential for the state to be able to argue everything they argued, which is exactly why, because Ronnie Sr. didn't testify, he didn't have the ability to say all this stuff was in fact evidence and he can argue it. Without Ronnie Jr.'s testimony, the state would have been handcuffed the same way. That probably wasn't a great analogy. Yeah, King T'Challa. I would say he was more than a little aggressive during the closing. He was looking, snarling at them, screaming at them. At one point, the prosecutor said, "Can you tell him to stop directing questions at me?" Again, when he said stuff like BS right in their face, screamed it. And the one that I actually had a hard time keeping a straight face is when he said, "You better watch your hands." I was like, what is he doing? Like, that's the type of stuff that to me is just not helping him. James Bellerose, I do not know how long he will serve on death row. Jeanette Jackson is back. Good to see you. He did not admit to murder. He admitted to justifiable homicide. A self-defense murder is what he admitted to. So Candy A, I thought he already tried to do insane, then he wasn't, so he represented himself. Could be wrong with so many cases going on, but I think that's what happened. So no, he was found not competent to stand trial. That's different than an insanity defense. So he didn't ever try an insanity defense. Once he was found to be competent, he eventually asked to represent himself. He invoked that right. He did represent himself, and he no longer went for an insanity plea. he could have still said temporary insanity at the time, even though he was competent now, but they never actually went with an insanity defense. Yes. Nuke, a jury of your peers. That's what you're supposed to have. Not a jury full of lawyers and not a judge. A jury of your peers. Now, you can waive that and have the judge make the decision if you really want to. Will something else be added because his son is a minor and a witness and had to testify? You can't really add much to the death penalty and multiple first-degree murder convictions, but we'll see. So Joanne said it's supposed to be reasonable people, and we as a community set the standard for what community we want to live in. Not just that, but part of the process is also you get to pick your lawyers, and your lawyers and you as the defendant or plaintiff or whatever party you may be in a case that goes to trial, you all together get to pick which jurors you want out of that pool of your peers and citizens. It's not just the first 6 or 12 that show up. You get to actually pick. I don't like this one for that reason. I do like this one. And you actually get to pick and be part of the process. It's really important. If you've never watched a jury trial before, you should. If you've never watched jury selection, if you get your jury summons, please go out there because it's something we need. Reasonable people. We need people that can think critically through these things and make reasonable decisions. Okay, that's what we need. So if you ever have the opportunity to do it, please do it. So Ty, people underestimate how easy it is to be prosecuted. I agree, and that's what I said in the beginning. The prosecution has all the power. They have all the levers. They have all the evidence. They get to make all the decisions. So it's an uphill battle for every criminal defendant in every case. Once you are arrested, it is an uphill battle. Most criminal defendants don't wait until they're charged or wait till long in the process to hire a lawyer. So Janet Young, too many mitigators to not get the death penalty. Tell me what you think those are. So you guys, do you think that there's a lot of mitigating factors, which means he's not going to get the death penalty? Let me know what you think. So Stacey Lincoln, have you seen how crooked our elected bodies are? I mean, a lot of people agree with that, and that's what Ronnie was trying to go into, especially with this political climate. He was trying to, I think, use that to say, this could happen to you. This is what's happening in Tampa Bay. Yeah, so Brennan Tube at Candy, he was deemed incompetent for about a year. Then May 2019, they said he's now competent. So, and that was just to go to trial, not to represent himself. So you have to understand the process, the charges against you, the severity of the crimes, and the potential punishments just to be competent to go to trial. Okay, so John DGR81, 5 hours. I guess the jury actually had to think about it. So let me know what you think, okay? As juror or as potential jurors and just people in the world and citizens out there, do you think 5 hours was a long time or a short period of time? Because I'm interested to see what you guys would say, because the lawyers would say that's not very long at all. 5 hours on a 6-day double murder jury trial is not very long in my opinion, but he just said they actually had to think about it. And if you heard the Derek Chauvin, when we broke down the juror who gave the interview, he talked about them being in and out, and he thought it should have actually been shorter. So let me know what you guys think. If you just hear that number, does 5 hours seem like a long time or a short period of time or the right amount of time? Let's see what else we have here. All right, so Robert Smith picked up on some minute detail, which I think is interesting, and I think that's good for jurors. And I am positive, Robert, that jurors do this. We've had jurors tell us after trial that they picked up on something that was really important to them, and we were like, that little detail? So I think, I don't know, we'll see. His son said, "It's good to see you too," to Ronnie Sr. He did. He didn't just not say anything, or he didn't just say, just get on with it, or I don't want to talk to you, or I don't want to see you. He didn't do any of that. So I don't know, maybe it will make a difference. So Goofy Goober, even if he did try to outright blame his wife for hurting the kids, do you think his evidence would have even supported that theory? Yes, if his evidence was his testimony. So a lot of people don't understand that testimony is evidence. And once somebody testifies to it on the witness stand under oath, it is evidence. So if he would have testified that his wife killed his daughter and then tried to kill him and tried to kill his son, that would have been evidence that would have supported that theory, which is why I thought he was going to take the stand. I thought based on his defenses that he brought up in opening that he was going to take the stand, and he decided not to. Therefore, there was no evidence of it. So some people are posting in here, the phone log won't make a difference at all. Man, it's cool to the bottom of this. All right, here we go. Yeah, so Goofy Goober, I was called for jury duty. It's $15 a day if selected. There are some places that pay you a little bit, give you lunch sometimes or dinner if you stay late. Okay, and M. Maxon Noodle. I know that's not what it actually says, but it's hard to read that one. How do they prove it's premeditated if he was at his parents' house all day? So I answered this a little bit earlier, but I'll give it again. Premeditation does not have to mean days or months or weeks of planning. They don't have to show you going to the store and buying ropes and gasoline and all this stuff. They don't have to do that to show premeditation. It just has to be something that you considered, reflected on, and decided to kill this person knowing that you were going to kill them. Okay, that's all it has to be. Him chasing her down to kill her, him hitting her 15 times, him screaming at her that I'm going to kill you, him on the 911 call where he was shooting bullets into the closet, him shooting her arm and then continuing to finish his plan to kill her. That, I guess, was enough for this jury to show premeditation. Why do you think he represented himself? Anna Sawyer, I think that he thought that was his best option. I don't think he thought anybody believed in his case. I've talked to clients in the past where either we're the second lawyer on the case, where they just don't believe a lawyer believes in their case. Maybe he couldn't find anybody that would make these arguments that he wanted to make and he felt was so strong about, the government corruption, about the doctored logs, about the doctored tapes, about the witness tampering. I don't think he could find a lawyer that would do it the way he wanted to with this self-defense defense. That's why he decided to just take the reins himself. So this is a good question. Little Miss Beauty, do you think having a lawyer would have changed the verdict? Do you think going pro se hurt him? Usually I would say yes, going pro se does hurt you. It's not usually a good decision, but I don't really know if I would say having a lawyer would change the verdict. I don't think so. Can he be found not competent to be executed at a later date? They do give some psychiatric exams throughout the process, even on death row. I don't know if I've ever heard someone, when it came time to actually execute them, from them saying they're not competent to be executed. So, Dark Stalker 0, the case definitely has grounds for appeal. Let me know what you think it is. I want to hear from you guys. What do you think is a ground for appeal in this case? I'm interested. So, the kid, Princess Charming, if he had a lawyer, what could have been a possible outcome in your opinion? So let me give my prior answer that I don't think a lawyer would have changed the verdict. One little potential change. I actually think there could have been a good insanity defense in this case. And I think not guilty by reason of insanity would have been his best argument, and a lawyer would have been able to put that on, obviously much better than he would have been able to do it. So that's the one nuance that I think having a lawyer may have actually changed the outcome. So Brenda Paddock, technically he changed it to killing his girlfriend in anger for killing their daughter in closing arguments, not self-defense. So you're right. You could make that argument if he said, this is why I killed my daughter. But throughout the whole trial, he's arguing it was actually self-defense, that he was defending his son and himself. He wasn't able to get there in time before killing his daughter. But that's a good nuance that you picked up on. So good question, Little Miss Beauty, of just about jury selection. Are attorneys turned away? No, we've had attorneys in our jury pool to pick from. And I've actually had one trial where I started with a lawyer on it. He ended up getting off for different reasons after, but we actually picked him to be on a 4-week federal criminal jury trial, which he was not too happy about being away from work for 4 weeks. Did his girlfriend have any of their daughter's blood on her? There was no evidence of that presented in the case. And Ronnie certainly didn't present any. So Jeanette Jones, I've done jury duty and it was a great experience. Good. I think that's great. I'd love to hear about anybody's jury experience. I love to hear about what they picked up on, what they liked, didn't like. I love anything like that. So anytime you want to get in the comments or write me an email even, I would love to hear about your experience, because any way I can get better as a trial lawyer, I'm going to do it. So Susan Lloyd, the jury has to leave their emotions out of it and just make their decisions based solely on the evidence. That's correct. But is it reasonable? If you were on this jury, would you be able to just leave your emotions just straight out of it? Because both Ronnie in his closing and the prosecution in their closing played on the emotions of the jury in different ways, but they both did it. That's always a hard thing for lawyers. We say keep your emotions out of it, but do you think jurors are actually able to do that? If I was a juror, I would have convicted him on every count except for maybe the attempted murder on his son, Ronnie Jr. Not because I believe necessarily he didn't do it, but I don't know if the state held their burden and proved it beyond reasonable doubt. I do think there were some inconsistencies. I think logically he probably did it, but that's not how I would make my decision on a juror. I would hold the prosecution to their burden and make sure they proved everything beyond a reasonable doubt. And I think they did prove first-degree murder against the mom, first-degree murder against the daughter, and arson. And then the other minor counts like resisting arrest, those are the less important counts that we're talking about with most of the evidence. So Guapo's Colt, he said, or he intimated that the mom killed the daughter. So he never admitted to killing the daughter. Yeah, so Babbitt, I agree. I try to be as pragmatic as possible, but this case was just sad, and I feel bad for the perpetrator. I feel bad for everybody. I mean, this guy, to me, has to have some mental issues to be able to kill his entire family and then act like this. I mean, it's sad for everybody. Okay, so here we go. Yeah, that's short from Chris H. Axelot, short. 5 hours is short from Brenda Paddock for a murder trial. That's a very short time for a murder trial. Who wants death in 5 hours? Short. 5 hours isn't long for a death penalty case from Latoya Esquire. Next up. So Candy A, I don't know. I watched the entire trial, had my mind made up after closing arguments, so it would be interesting why it took 5 hours. You have to go through all of the evidence again. You can't just go, I mean, you can, I guess, as a jury, but you're not supposed to. You're instructed to go back there, look at the evidence again, talk it over. Most time juries take an initial vote. They talk about the evidence, then they take another vote. And if it's unanimous, then they fill out the paperwork, which you still have to fill out the paperwork and actually put your verdict down and sign it. So, I mean, there are certain things that take time. It's probably not 5 hours of them discussing it, but I think it's a short period of time. All right, so China Williams, but in his case, not true. Now, there are some cases that are dirty, but in this case, not so. And no, 5 hours, not long at all. So I agree with you. I mean, I definitely think we've had cases where law enforcement has destroyed evidence. We've had cases where prosecutors are less than ethical. I'm sure there are cases where defense attorneys are less than ethical. So yeah, I'm not saying that there's no corruption in the world. There is. I just don't think he showed any in this case personally. 5 hours, not a long time. So yeah, Goofy Goober again said they had to go through a few pieces of evidence. People saying they had lunch as well. Barry on said barely enough time to go through the evidence. Yeah, everybody's saying. Okay, so here's something we haven't heard yet. Sashi Soon says, kudos to the judge for encouraging Ronnie to get counsel for the death penalty phase. I agree. I think he should get counsel for that portion. Very few people have actually argued during that phase, even lawyers. The real question, am I a Bucks fan? Oh, gosh, this is very weird looking in this camera. Yes, I am a Bucks fan. Very fun. Super Bowl champs, baby. Let's see here. Tracy Lee Bryant, you're late because you didn't go Eastern Standard Time. I don't know if that's a joke based on the call logs and what Ronnie said, but you can always go back. We're going to post it to YouTube. Again, I'll take this time. We're almost done. I'm going to keep going a little bit longer until I finish all the comments. Please subscribe to our page. We'll do more of it. We'll talk more about this trial and other ones. I love having you guys here. This is so much fun to get your input and your insight on what actual jurors would determine in this type of situation and others. So I'd love to discuss more cases with you guys. I appreciate the time and thought that you put into this, giving me your thoughts and your perspective. So I love that. And I definitely want to do more of it if you guys do. So some people are saying, I think the son did it out of respect. When talking about his son, said, good to see you too. And other people said his son was just scared. Okay, so Charity Dunning, prosecution didn't seem like they had to work that hard during this trial. I disagree. It's really hard dealing with a pro se defendant. You never know what a guy like this is going to do. You never know. Okay, so Richard McGee, jurors do whatever prosecutors say. You know how many wrongful convictions there are. I agree there are a lot of wrongful convictions, and I agree that jurors usually lean toward the prosecution, but there's a reason for that. We have somebody who's been arrested and charged and has witnesses against them for a crime, right? So that's usually why they lean toward the prosecution, but that's why the prosecution has such a high burden and the defense does not have a burden at all. But I agree with you that a lot of times they do lean, and a lot of judges do too, which is tough. A lot of judges lean toward the prosecution. All right, Little Miss Beauty, you've commented a lot on how Ronnie Sr. did on the defense side, but can you tell us your thoughts, any critiques, comments on how the prosecutors did? So at the beginning of this, I did take some time to talk about the prosecutor's closing argument because I agree with you. I did focus so much on what Ronnie did because that was the crazy part of the case and really impressive for a lot of the time. I thought the prosecutors did a really good job of staying calm, not being overly aggressive with the pro se defendant. As I mentioned before, it's not easy. They may have made it look easy because they were calm throughout the process, but I think their job is so much easier. They have all this evidence. They have all the common sense on their side. They have a guy arguing conspiracy theory and that everybody's involved in this huge conspiracy, even Ronnie Sr.'s neighbors. You know, so that's the issue. They have a guy pointing out the fact that he only beat his wife 3 times in the head is a good fact and calling witnesses like that to the stand. That's the witness they have to cross-examine, as opposed to who Ronnie Sr. has to cross-examine, which is a seasoned detective who has done this a million times and has been through way more trials than Ronnie ever will. So I think the prosecutor's job is much easier in a case like this, but I think they did a great job. I think the hardest part is not getting frustrated by the pro se defendant and not being too overly aggressive or going at him too hard like they may have done against a private defense attorney. So I think their calmness was really good throughout the process, but I don't think they held back. I think they went at him. I think they pointed at him. I think they showed they weren't scared to prove that this guy committed the murder of all of his family. And they were really hitting home hard that he was a menace to society, and this is one of the worst of the worst. So King T'Challa, Ronnie needed better evidence. This wasn't what I expected after closing. I think he should let his attorneys represent him for the death penalty. That's always a problem. When you don't have the evidence, it's really hard to argue a case. And I agree with you. I just don't think he had the evidence in this case. So Vicky Shack, what do I think he did wrong in his defense? I think there were a couple technical errors, like saying clear and convincing evidence. I think he came off like saying, you better watch your hands, and threatening the prosecutor. I think the screaming was not great. I really think those were kind of his mistakes, is what he was doing while he wasn't presenting. Okay, because when he was presenting and asking questions, I think he did a good job. I think his arguments with the judge are bad. Generally speaking, I know we've had some comments that the jurors do whatever the prosecutors say. Jurors love judges. Usually, judges can do no wrong in the mind of a juror for the most part. So when you argue with the judge and get angry at the judge and start to act like the judge may be in on it, that's also something that is a big no-no in trials. So Chuck Robinson, when you were on a jury, first thing you did was take a vote, just see where they were. That's commonplace. That's everything I've heard from almost every jury, is they start with a vote, then they talk about all the evidence, and then they vote again at the end. So Zahara Morea, this could have been a different outcome. Tell me what you mean. How could it have been a different outcome? Alex Albino, do you think the defendant coached his son like he said? What's your definition of coached? Okay, so yes, was he coached? But are tons of witnesses in every trial coached? Yes. Was he coerced? Do I think he told the son to lie? Do I think he told the son to change his story? No. But do I think they maybe practiced what the son was going to say? Absolutely. I think they did practice it. I think they wanted the son to be ready for it. I think they tried to prepare him as much as he could to be ready to talk to his dad again, who he hasn't spoken to since the night all this happened. If you call that coaching, then yes, I think he was coached, but I don't think he was coerced, and I don't think they told him to lie or anything like that. Okay, so here's Virginia. This is a good tidbit. The jury asked for the transcript that described Miss Barron's injuries just before the verdict. Okay, so they were thinking about it. Is he a sure thing for the death penalty? I don't know. I would lean towards yes. Candy, of course, I'm a Tom Brady fan. Come on. Who's not? Even people not in Tampa are a Tom Brady fan. Goofy Goober, if he had hired you with everything you know and the evidence, would you have defended him? So we have defended people accused of things like this, right? And it's hard to know. It's hard to know what is the truth and what's not, right? So you look through the evidence, you do the best you can. We've even hired people that have said, I did it, and worked out a deal with the state. So it's not that you only represent people that are not guilty or innocent. There's a lot of different factors in determining what clients you're going to take on and what clients you're not. There are some cases I personally wouldn't take, but other lawyers in my firm would. So it all really depends on kind of a case-by-case basis. Cement Shoes thinks he should have cut a deal. So Brandon Love, do you think he failed to cross-examine the witnesses thoroughly enough? I think he did the best he could with what he had. I mean, what else did you want him to ask him? That's the problem, is what else could he have possibly asked them? That's kind of what my issue was. I think he went through all the evidence big time with his son. I mean, he had stacks of witness statements and depositions where he pointed out all the inconsistencies, and he went through them pretty thoroughly with the son. Thank you, Max and Yodel. I feel sorry for the boy as well. It's terrible. Fine China, I think the prosecution did do a good enough job since we've seen the verdict has come down guilty on all counts. So, Pink You Pet, I've heard a bunch of different stories around this, but I have heard that Ronnie Jr. was actually placed with some family members first who did not do a good job taking care of him. They needed somewhere to put him. The detective just kind of stepped up and said, we'll take him for a little while, and then it ended up sticking, which happens a lot. But I don't think it was like officially through the foster care system, but I don't know that. That's all just kind of hearsay or hearing things through the grapevine. So I don't really know. He could have gone through the foster system. Yeah, Anthony Capello, one of the issues was they did say all their names. They showed pictures of minors with these gruesome injuries, and they let all the cursing go through, which is why a lot of those clips are not up to view on YouTube anymore. So Butterfly, the judge looked disgusted to me while she was watching Ronnie. She was like smirking some of the time. She did look disgusted sometimes. She was ready to pounce on him, basically anything he said. Okay, so Rashad Zellner. I agree, and I just kind of mentioned this. The judge, I think, did have some facial expressions. I don't think it was anywhere near enough to grant an appeal. It just scanned to the bottom again. Somebody asked if it was up to the judge, or if it ends up being up to the judge, what do you think she'll do? I think she'll go with whatever the jury decides. There we go. Yeah, see, that was your question. I don't think his appearance was bad. He was wearing a nice suit the whole time. I guess some people had comments about his hair, and I don't think his appearance was bad. Lauren S. Hopefully Tom fares better this time than last time he was on the course. Yeah, Tony Lewis. Why wouldn't he want to testify to clear up what happened? I agree. I was wrong. On the live video we did last time, I don't know if some of you guys were there. I said I thought he was going to testify. I think he had to testify. I think based on his defenses, based on his opening statement, his closing argument, he had to testify and he didn't. And I think that was a miss on his part. That was the worst thing he did, the worst maneuver or move he made. I saw people praising it like, haha, he gets to testify without cross-examination. I mean, nobody's believing what he's saying. Obviously, the jury wasn't believing what he was saying at all. So how bad is cross-examination going to go for you? The prosecutors already get to make all their arguments. I would have testified if I was him. So Max Noodle, You got to get an easier name for me to read or tell me how to say it. Maxine Odell. Maybe that's what it is. Maxine Odell. I was wondering if you post any trials that you have personally been a lawyer in. I don't know what you mean by post them, but we talk about them sometimes. We definitely talk about them a lot with clients when we explain any similarities that may happen in a trial. We'll probably talk about some on the channel. If you guys want to hear them, we can talk about them. I've only been doing this for, I don't know, less than a year doing YouTube stuff. So if you want to hear about them, I'm happy to talk to you guys about some of them, everything that I can. Some of it's confidential, some of it's privileged, but yeah, we can talk about a lot of the trials that we've done and what some of the differences are and what some of the interesting factors of them are, because we've had some crazy trials happen over the last few years. And then my dad's been practicing for 40 years. So he's had some crazy trial experiences as well. So Christopher Dilworth, I think he's going to receive the death penalty, but we will see. I mean, this is a pretty heinous crime. He was convicted of it. So I think it's a formality at this point. Is it normal? So Little Miss Beauty again, is it normal for a defendant not to react to a guilty verdict? Do you think that being filmed was part of his non-reaction? I don't know. I would say we've had some that literally pass out and fall down with a guilty verdict. Some scream and cry. Some, we had one guy try to run around the courtroom screaming reasonable doubt, reasonable doubt. We've had some weird reactions, but we've also seen some stoic ones. We've also had some that were going bad during the trial. We kind of knew it was going to happen, so they knew it was coming. We already started talking about appeals. So every case is really different. George Daly, I'm sorry to hear that. You have a wrongful death trial coming up on 7/26, and I wish you nothing but the absolute best in that. Those are tough, tough cases as well. Do you think his called witnesses hurt him? The 3 verse 15, I agree. Candy, I think they did hurt him. I think the fact that the best thing, and he doubled and tripled down. I called that witness. I called that witness. They didn't call him. It's like, yeah, dude, but the witness still said that you bludgeoned her to death 3 times. He watched you and it didn't look like self-defense to him. So I don't think that was good for him, but it did show another inconsistency. And that's one of the things he said he was going to prove. And he says it proved more self-defense than premeditated murder, because 15 hits to the head shows more murder, I guess, in his mind. I don't think they helped him, though, personally. Bunch of people asking his chances of the death penalty. I think they are high. Candy A. All right, I guess I'll answer some of the budding questions here. Seriously, what kind of attorney are you? Like everyone is saying, your looks would be very distracting. This could be a great thing or possibly a bad thing. I guess I've never had that. Never had anybody tell me my looks would be distracting before. I'm a personal injury lawyer, car accidents, slip and falls, wrongful death. We also do nursing home negligence cases, nursing home abuse, which is also some of the worst cases you can hear. And then we also have lawyers in our firm that practice criminal defense as well. I practiced criminal defense early in my career, and I do a little bit of it. I don't do a ton of criminal defense anymore, but I've got over 20 criminal trials that I've done. But mostly what I do now is car accidents, slip and falls, injury cases, wrongful death, traumatic brain injury cases, nursing home negligence cases. No, LaToya, definitely not. This was not a high enough profile case to be moved to a different county. Definitely not, especially if the Chauvin case was not moved. It's a pretty high burden. It's not a normal thing. I know we talked about it a lot, and a lot of people talked about it for the Derek Chauvin trial. It's really unusual. We've had cases that are all over the news, and they still go to trial in Tampa. LaToya Esquire up next. Good. I'm glad you're learning a lot. That's the goal here for you guys, and we learn together. We teach each other stuff. That's the goal here. Oh, I didn't realize you were talking about me, Vicky. Sorry. I'm married with children. I am. Looks can be extremely distracting. Okay, let's see if we have any more case questions. Okay, anything else? Okay, here we go. Maybe we'll end with this one. Carrie Boyer, what's the worst case you ever took on? So we had a case, we've had some cases, I don't know, it depends on what your definition is of worst. I mean, we've had some capital sexual battery cases that are really tough. We've had some weapons of mass destruction cases, people trying to buy bombs, plant bombs, conspiracy cases like that. We've had some bad ones, you know, I mean, it's tough, and we've won some of them when it just didn't happen and they were innocent. And then we've lost some of them and we've pled some of them, you know, where they got a deal of some sort. So there are some bad cases all along the spectrum. I mean, but there are also some DUIs, like a simple case like a DUI that you think can be so despicable that somebody could act like they do throughout the case. But then there are other cases where it's just they're just wrong and they're wrongfully arrested and we've got to go to trial. We've had cases where we've gone a 5-day DUI trial. We got a hung jury, which means the jury could not agree and ended up getting the charges reduced at the end, but the state just wouldn't drop it, even though they didn't have proof for it. But because, like you said, a lot of times jurors lean towards prosecutors or lean towards judges, it was hard. So yeah, I've talked to my dad, Latoya, I've talked to my dad a bunch about it. And I mean, he agreed. He thought that he did a good job. He really thinks he did a good job as a pro se defendant, but he thought he was guilty. He thought there was too much evidence against him. We pretty much agreed throughout the process. He's who I learned from. So the first couple of years I was a lawyer, all I did was criminal defense, and he's who I learned from. My second chair, a bunch of big trials that he was on, federal criminal trials. And so I learned from the best. He's one of the best criminal defense lawyers in the entire country. People travel from all places to try to hire him to be their criminal defense lawyer. Okay, let's end with this. Devin Holmes, subscribe. Please, everybody, go subscribe. We're about to sign off. This was so much fun. We've got to do more of these. I'm going to plan to do more of these. I do have to take time away from my kids that we've mentioned, but it's so fun. I love doing it with you guys. I appreciate all the questions. I appreciate all the comments. Keep them coming, but please go subscribe. The more people we have come to this, the better sample size we can get of what people are thinking and how we can make things better. I'm on the civil rules committee in Florida. I help write the civil rules that we use in our trials and in our court system. So if I can hear what the people are thinking, that can help us. We can literally be on the grassroots level. Yeah, check out the podcast too. Thanks, Latoya. I needed to bring you on. You're helping me out. So yeah, check out the podcast because I would love to hear what you guys think. I would love to bring it to the people that matter, and we can make a change if you guys think it's necessary. Thanks for sharing your thoughts and experiences with me. Let's do more of it later. But for now, I'm going to hit end broadcast.